Okay, welcome to Lecture 10. This is Lindsay Clark. I am your primary instructor for current topics in medical laboratory sciences. Today we are going to talk about HIPAA and social media. So I know most, if not all of you, have been trained on HIPAA, but I do want to touch on how it relates to social media. So the objectives for today's lecture are to define HIPAA and discuss the three major rules included in HIPAA, determine what does and does not constitute PHI, explain who is required to comply with HIPAA rules, and recognize components of social media posts that violate HIPAA rules. So what is HIPAA? That's HIPAA, not HIPPA. So when people put the picture of the hippo up for HIPAA, I get really annoyed because it is not HIPP, it is HIPAA. So make sure that you guys keep that straight. So HIPAA stands for Health Insurance Portability and Accountability Act. This act was passed in 1996 while President Bill Clinton was in office, and the law was passed to increase patient privacy and protect against unauthorized release of individually identifiable health information. Now, this act also gave individuals the right to their own health information. And there are three major rules of HIPAA, which we'll talk about in more detail, and those are the privacy rule, the security rule, and the breach notification rule. The HIPAA privacy rule established standards for when PHI may be used or disclosed and set standards for how to use, manage, and protect PHI. The privacy rule also gave individuals the right to examine and obtain copies of their own health records. And for those of you that need a little bit of review, PHI stands for Protected Health Information, which we'll talk about a little bit more coming up. So again, protected health information. What is PHI? So PHI includes any information that relates to the individual's past, present, or future medical condition, whether physical or mental. It also includes any information regarding the delivery of health care to the individual, as well as any financial or payment information. Now, almost all health information is considered PHI when it contains individual identifiers. And HIPAA has a list of 18 identifiers that make health information PHI. So the simple formula here, just remember, health information plus identifier equals protected health information. Meaning if you release that unauthorized, you are in violation of HIPAA. So the 18 identifiers that make health information PHI are names, dates with the exception of the year, telephone numbers, geographic data, fax numbers, social security numbers, email addresses, medical record numbers, any account numbers, health plan beneficiary numbers, certificate or license numbers, vehicle identifiers and serial numbers, and this includes license plates, web URLs, device identifiers and serial numbers, IP addresses or Internet Protocol addresses, full face photos and comparable images such as those as a unique tattoo or something that could identify that patient, biometric identifiers such as fingerprints or retinal scans, and any unique identifying number or code. So any of these identifiers must be removed from health information before it is disclosed, or the disclosure could result in a HIPAA violation. Also, just because you removed these identifiers does not mean it is not a HIPAA violation. If you post enough information for that patient to potentially be identified, you may be in violation. And we'll talk more about this in a bit. So the HIPAA security rule simply states that covered entities and business associates must have safeguards in place to protect PHI or ePHI, which is electronic protected health information. And they are responsible for protecting any PHI or ePHI they create, receive, maintain, or transmit. They're also responsible for protecting against any reasonably anticipated threats to PHI or reasonably anticipated impermissible uses or disclosures of ePHI. And some of you may know this, but covered entities include covered healthcare providers, health plans, and healthcare clearinghouses. And business associates refers to any agency or business covered entities are doing business with. The breach notification rule. So this requires covered entities to notify affected individuals, as well as the U.S. Department of Health and Human Services, and in some cases even the media, of a breach of unsecured PHI. Most notifications are required to take place within 60 days of the discovery of a breach. So who is required to comply with HIPAA? So all covered entities and their business associates, which we talked about a little earlier, but we'll talk about a little bit more here. Covered entities includes covered healthcare providers, health plans, and healthcare clearinghouses. A covered healthcare provider is any provider of medical or other healthcare services or supplies who transmits any health information in electronic form in connection with a transaction for which HHS has adopted a standard. This includes chiropractors, clinics, dentists, doctors, pharmacies, laboratory personnel, and many, many others in the healthcare field. So a health plan is any individual or group plan that provides or pays the cost of health care, such as company health plans, government programs like Medicare, Medicaid, health insurance companies, and even HMOs. Now, healthcare clearinghouses are public or private entities that process another entity's healthcare transactions, such as billing services, community health management information systems, or repricing companies. Now, business associates refers to any businesses doing business with the covered entity. So we can include here accreditation agencies, billing, consulting, any data analysis companies, legal services, and anything along those lines. So HIPAA and CLIA. How does HIPAA directly relate to the lab? So in 2014, the final rule amended CLIA 88 to allow labs to give a patient or a patient's representative direct access to that patient's complete test reports at their request. However, test reports may only be released to authorized persons. Patients cannot call the laboratory and request verbal results. And often, hospital policy will dictate they must still go through medical records to obtain any part of their record. So now that we have reviewed HIPAA, what are some of the most common violations that healthcare employees commit? So according to the website HIPAAjournal.com, which has lots and lots of information about HIPAA, these are the top 10 violations by healthcare employees, and they include snooping in medical records that you have no business snooping in, emailing PHI to personal email accounts, removing PHI from the facility, leaving portable devices or paperwork unattended, releasing patient information to an unauthorized person, releasing patient information without authorization, disclosure of PHI to third parties after authorization has already expired, impermissible disclosures, downloading PHI onto unauthorized devices, and providing unauthorized access to medical records. So these are actually violations that are commonly committed by healthcare employees in general. These are not laboratory specific. But if you look through this list, there are some of these that could be done in the laboratory. So let's talk about social media and HIPAA. So the use of social media in the past 10 years or so has really skyrocketed. Social media platforms like Facebook, Twitter, Instagram have been embraced by some members of the healthcare community, while others not so much. They have proven to be great educational tools, and they allow for professional networking, organizational promotion, patient education, and even promoting the laboratory profession. However, you have to be careful that you are not violating HIPAA when posting case studies, images, questions, funky cell, pictures, anything like that on social media. And the dangers of social media can include damage to your professional image, HIPAA violations, and even legal issues. So next we're going to look at a few specific examples of HIPAA violations on social media. So, our first example actually involves an MLT who commented on a Facebook page about a patient killed in a car crash. She made comments on news stories reporting the crash and commented, "Should have worn her seatbelt." She also responded to another comment and stated, "Yep, I was working today when they came in the ER." These comments were deemed HIPAA violations by her hospital because they confirmed that the family was being treated there. So this is a situation where she didn't actually state any identifiers or patient information, but because of the combination of the information found in the articles that she was commenting on, as well as being able to identify which hospital this individual worked in, actually all of those together constituted a HIPAA violation. Now, our next example involves a nurse at Texas Children's Hospital who posted in an anti-vaccination group about a measles patient at her facility. So because her job title and place of employment was listed on her profile, and she was posting about a child with an uncommon diagnosis, her comments could have allowed members of Facebook to be able to identify that patient. She was actually in violation of HIPAA for posting in this group, and someone in the group actually screenshotted her comments and sent it to the hospital. And so they were able to find out that she made these comments online and that it was indeed a violation of HIPAA, and she lost her job for that. Now, our third example is actually from UAMS. So just last year, an employee in one of the clinics disclosed health information to their coworker, and that information included the patient's name, their age, HIV status, employment information, and surgical history. The coworker that had this information then shared that with a friend who uploaded it to Facebook. So those two employees were fired. But there was also a third employee fired, not for being involved in the violation, but because they were aware of the unauthorized disclosures and failed to report them, and that violated the hospital's code of conduct. So in this instance, that third employee knew this was going on and didn't say anything. They ended up losing their job as well. So if you see something, say something. That's how the saying goes, right? So, should you stay off social media forever and never engage in any educational posts or networking? Of course not, but you have to be smart about it. If your institution has a social media policy, and I bet it does, follow it. You should also follow any social media guidelines issued by professional organizations. At this time, I don't believe there are any laboratory-specific guidelines for social media posting. That could change in the future, of course. In addition, you should avoid posting images of faces, any unique tattoos, or any other features which could be used to identify a patient without their permission. Always avoid mention of small geographic areas. So a good rule of thumb here is to avoid anything smaller than a state. Exclude ages for patients over 89 and children. And in general, approximate ages are a good idea. Never use dates and avoid posting things like, today I saw a rare case of blah, blah, blah. That can really narrow down cases and places for patients and can lead people to be able to identify those patients. So it is also recommended to modify clinical history. So you can maintain relevance while protecting any potential identifying information by just slightly modifying the clinical history. So if you have something interesting, a case study that you want to post, I highly recommend that you do that as long as you're being smart about it and not violating any HIPAA rules. So if you have a case that maybe you have a bunch of monos on a peripheral blood smear and you want to post a little case study, well, maybe the patient you saw was a 12-year-old male patient. So in your case study, you can just simply change that to a female patient approximately 16 years of age. So if you change all of that information and it's not about a specific patient, that's actually recommended to do that. Just kind of make it a little bit more vague, change enough information where they will not be able to identify the actual patient. And on that note, I do recommend using social media for educational tools. So follow good social media pages, find anything that is helpful for you guys, especially as students. Follow your professional organization, Facebook pages, Twitter pages, Instagram pages, all that good stuff. Don't totally shy away from it, but please be smart about it. So that brings us to the end of our lecture. As always, please contact me if you have any questions, comments, or concerns, and that's my contact information at the bottom of the screen. I am going to post an article that I would like you all to read to go along with this lecture, and the title of that article is Pathology Image Sharing on Social Media, Recommendations for Protecting Privacy While Motivating Education. This is actually an article that is written by a pathologist or co-written by a pathologist at UAMS named Jared Gardner, and he has actually really done a lot of work with using social media as an educational tool, especially in pathology. He has a Twitter page, a Facebook page, I'm sure other pages, but if you guys are on those social media platforms, I recommend following him, and I want you to read through this article because it's a really good article about using social media for educational purposes while still protecting yourself on that. Alright, I hope you guys enjoyed this lecture, and I will see you guys for the next lecture.